Good evening, America. I'm Sam Gold. In our quest to bring you the latest news of interest to America's injured workers, we bring you the story behind the story. Not just old news off WorkCompCentral.com, like the others do. A story that has been in the news of recent has unusual ramifications, if successful in the courts. It's a topic that we've been proselytizing about for the last 5 years. The use of the Federal Racketeer Influenced and Corrupt Organizations Act, also known as RICO, to hold employers, insurers, and their dock-in-the-box physicians accountable for their fraudulent acts that they perpetrate in the workers' compensation process. A federal appeals court has cleared the way for discovery to begin in a RICO lawsuit that accuses insurance administrator Crawford and Company and an Illinois trucking business of colluding with a Michigan doctor to falsely deny workers their workers' compensation claims. After being ordered by the U.S. Supreme Court to reconsider an earlier decision, the U.S. Sixth Circuit Court in Michigan reversed a district court's decision to dismiss a civil complaint under the RICO law filed by 6 current and former employees of Cassens Transport Company, Crawford and Company, and physician Dr. Saul Margulies. In the conclusion of its 13-page opinion, the appeals court said that it reversed the dismissal of plaintiffs' RICO claims because their RICO claims are not preempted by state law, and because plaintiffs have adequately pleaded a pattern of racketeering activity despite the lack of reliance on the defendant's fraudulent acts, and remand to the district court for further proceedings consistent with this opinion. The court affirmed the dismissal of the intentional infliction of emotional distress claims because the defendants' alleged actions cannot meet Michigan's standard for outrageous conduct. The appeals court reported in June 2004 the plaintiffs filed a complaint raising RICO and intentional infliction of emotional distress claims against the defendants. The plaintiffs alleged that Cassens, which was self-insured for workers' compensation, had contracted with Crawford to serve as a claims adjuster. They further pleaded that Cassens, Crawford, and Margulies, as well as other cutoff doctors, engaged in a pattern of racketeering activity that denied the plaintiffs' workers' compensation claims. The court wrote, specifically the plaintiffs alleged that Cassens and Crawford deliberately selected and paid unqualified doctors, including Margulies, to give fraudulent medical opinions that would support the denial of workers' compensation benefits, and that defendants ignored other medical evidence in denying them benefits. The plaintiffs also claimed that the defendants made fraudulent communications amongst themselves and to the plaintiffs by mail and wire, bringing them under the jurisdiction of the RICO statutes, the court wrote. As you're probably aware, the federal RICO statutes were designed to bring organized crime activities to justice in the past. The workers' lawyer, Marshall Lasser of Southfield, Michigan, said his RICO action represents a new strategy in his state to make employers and insurers accountable for their fraudulent practices. No recourse seems to be available in state workers' compensation systems anywhere, Lasser said. With us tonight by telephone is Michigan attorney Marshall Lasser to fill us in on the details of this most unusual lawsuit that might just open the floodgates for America's attorneys to finally get justice for their injured worker clients. And conducting the interview tonight is our special guest attorney, Sam Lasser, who is a California criminal defense attorney.
Good evening, folks. My name is Samuel Lasser. I'm an attorney here in San Francisco, and I practice mostly criminal defense work. And I'm here today via telephone is Marshall Lasser, an attorney from Michigan. And Marshall, we're very glad to have you on the show. And he's going to talk to us today about his legal efforts to pursue justice on behalf of injured workers in Michigan. against insurance companies who are fraudulently denying these injured workers benefits. Good evening, Mr. Lasser.
Good evening.
Thank you again for being on the show. I want to just get a little background information about yourself and where you are, or who you are, and what you do, and how you've gotten to this point. So why don't you tell us what your law practice is, how long you've been practicing law, and what does your practice entail?
I graduated Harvard Law School in 1973. In fact, I did work in San Francisco for a couple of years. After that, I moved back to Michigan, worked several years for Ford Motor Company in the Office of General Counsel, where we defended product liability cases. Then in the late 1970s, I went out on my own, primarily representing Teamsters and building tradesmen in workers' compensation and product liability and general negligence claims, such as slip and falls, auto accidents. And in the last, I'd say in the last 30 years then, that's what I've done pretty much exclusively. Recently, due to changes in the law in Michigan, it's been more workers' compensation than personal injury third-party cases.
So for the past 30 or so years, you've handled primarily or exclusively plaintiff side personal injury and workers' compensation cases?
Yes, that's correct. I work only on the plaintiff side.
And through your years of practice, I just want to get a lead in to where we are, what we're talking about today, in the RICO lawsuit. But through your years of working in the workers' comp system, you've obviously seen a tremendous amount, or you've seen a great deal, and you understand how the system operates. And could you explain to us a little, what it is about the system, the workers' comp system, that has frustrated you the most throughout your years of practice?
Good question, Sam. I became really, really upset and disgusted with the way the insurance companies cut people off or deny benefits unconscionably, and I believe, and this is what I'm hoping to prove in my RICO cases, fraudulently. Injured workers don't have a $100,000 or $200,000 cushion in case they're injured on the job. They live close to the edge financially, most of them, and they desperately need their workers' comp in order to pay their rent or mortgage, to keep their spouses from leaving, to buy food, and of course to pay for their injuries, for medical care for their injuries. And about 10, 12 years ago, I became disgusted by two different elements, two different things in the workers' comp system. In Michigan, there is no punishment for workers' compensation insurers or the so-called IME, independent medical exam doctors they use, if either the insurers or the doctors lie or commit fraud. There's simply no punishment. They get away with it. So what I believe this has encouraged and fostered is two types of bad things. The first thing is the insurance company claim adjuster cutting off benefits or denying benefits right from the start using fraudulent reasons. In Michigan, they have to file with the state of Michigan a document called a notice of dispute. They have to file that with what is now called the Workers' Compensation Agency. And in the notice of dispute, they have to state the reason why they're denying benefits. And the reason can be just complete baloney. There's no punishment for it. And that really enraged me. It really embittered me to see people hurt so badly by what I thought was bald-faced lying in a lot of cases. Then the other problem, which is even bigger probably, is the use of so-called IME, independent medical exam doctors, to wrongfully, in my opinion, wrongfully and even fraudulently deny workers' comp right from the start, or to cut it off after a person has been on workers' comp for a period of time. Those are the two problems that really got me going.
Now, these problems that you're talking about, are these are these problems that have arisen in the past 5 or 10 years, or are these problems that you saw from the outset of your practice and your beginning to practice?
I remember I really got into workers' comp in a heavy way in the early and mid '80s, and I remember distinctly a deposition that I took in 1993 in Flint, Michigan, of a think he was an orthopedic surgeon or a neurosurgeon by the name of Melvin Wolf. And he admitted on the record that in he does IMEs for insurance companies and self-insured employers. General Motors, for example, is a large self-insured employer. And he was grossing $750,000 a year. This is back in 1993. And it doesn't take much to realize there is, very little overhead for that type of business. You need a secretary. Maybe you need an X-ray technician to take X-ray. You don't have to pay medical malpractice premiums for that because in Michigan, no matter what you say in your IME report, you can't be sued. So I was just stunned that this doctor could make this kind of money, gross $750, maybe netting $650, $675 back in 1993 from churning out thousands of these reports for insurance companies and the defendants. That's when I really first saw the problem, but I didn't see RICO as a possible tool until much later.
And so it's the, as you said, it's the unavailability of any remedy under state law, under Michigan law, for these injured workers who are being fraudulently or who are fraudulently denied benefits. They really have no recourse under state law. So where do you go from there, and how did you find RICO as the avenue to pursue these claims?
Today is 2008, so it was somewhere around 2002, 2003 and I'm not sure how it was that I thought of RICO as being an avenue for what I believe is the fraudulent denial of workers' comp. But it was about that time, 2002, 2003, that I brought 2003, I think, was when I brought my first case. Not sure how I realized I put two and two together, that this presented an avenue. But it was about 2003 that I believe it was that I brought my first case that preceded the one that finally won.
Can you explain a little bit as to why RICO, the Racketeer Influenced Corrupt Organization Law, why you selected that law to go after the insurance companies and the employers?
RICO, a lot of reasons. One of which it provides for treble damages, it provides for attorney fees, it allows you to sue the people who commit the racketeering acts, possibly the doctors, possibly the claim adjusters, the companies that employ these people. It is allows tremendous discovery. Why very, very wide open discovery. Person can discover conduct discovery not just about the acts about which he has pled in his complaint, but he can discover all similar acts.
Well, but before I'll get into the discovery aspect of it later. How did you? What proceedings did you initiate back in 2003 or 2004? How did you get the ball rolling on this on these claims?
The first case I filed was on behalf of a single individual who was, I believe, defrauded by an IME doctor and a claim adjuster. That case was quickly thrown out of district court under Rule 12b-6, Federal District Court under Rule 12b-6.
And basically, can you explain what that means in common terms?
Okay. RICO is, of course, the Racketeering Influenced Corrupt Organization Law, passed in, I think, the late 60s, early 70s. And when a plaintiff files a RICO pleading, the defense attorneys scan it very carefully and look for any basis to have it dismissed on the pleadings, before any depositions are taken, before any discovery takes place. And what happened in each of my three cases is that a motion is filed under Rule 12b-6, which allows for dismissal for failure to state a claim. What the judge does there, he examines the complaint and determines whether the allegations are sufficient under federal law to state a claim. And
one of the most difficult parts of filing this type of lawsuit is making it past a defense motion to dismiss the pleadings. Is that a fair statement?
Certainly.
Do you find that the courts are receptive to these types of lawsuits, or do you have the inkling that they want to side with the defense? Do you have any
Well,
position on that?
In the 3 attempts that I had here in the U.S. District Court in Michigan, 2 cases were handled by one district judge, and the third by a second district judge. And in every case, they were dismissed on the pleadings. Actually, the judge was required to dismiss on the pleadings because I was seeking to overturn a precedent, Sixth Circuit precedent. Detroit, Michigan, is within the United States within the jurisdiction, the United States Court of Appeals for the Sixth Circuit, which includes Michigan, Ohio, Tennessee, and Kentucky. So the district judge was required, in fact, to dismiss the case under this precedent. But nevertheless, the 3 district judges, or the 2 district judges who handled these 3 cases, were hostile to the case. They were really intensely skeptical of the idea that a defense IME doctor could be committing fraud, let alone widespread fraud, which is what I do believe happens. So there was definitely hostility, I believe, or maybe hostility is too strong a word, but real strong skepticism on the part of the U.S. District Court judges here.
And well, I want to talk about how you got to this most recent decision, your victory in the Sixth Circuit Court of Appeals, a decision that came down October 23rd of 2008, in which the Court of Appeals, reversed the district court's decision and allowed you to proceed with your claims and get to the discovery stage of litigation. Where has this case been in the courts to get it to this point?
Okay. This case involves, the defendants are, let me explain the parties. There are 6 plaintiffs, 6 truck drivers as plaintiffs, and there are 3 defendants. The truck drivers are employed by Cassens Trucking. Workers' comp claims for Cassens Trucking are adjusted by Crawford & Company. And in the case of several of the plaintiffs, when a person's injured on the job, he was sent back that time to Dr. Saul Margulies. I believed that of the 6 plaintiffs, some of them were fraudulently denied workers' comp on the basis of false notices of dispute. In a couple of other cases, I believe that Dr. Saul Margulies fraudulently wrote fraudulent reports, which were immediately followed up by notices of dispute, relying on those medical reports. That's what I alleged. This is 2004, I believe. Anyways, the defense, of course, makes its motion under Rule 12b-6 to dismiss for failure to state a claim, and the district judge grants the motion on really about 5 or 6 different grounds. Not only the ground that there was a precedent which required a misrepresentation of the plaintiff upon which he relied, but several other grounds. For example, he claimed, and you'll hear more about this later, the defendants claimed that the case should have been preempted under something called the McCarran-Ferguson reverse preemption. This is getting a little complicated, but the insurance industry in the United States is basically exempt from antitrust. Amazing, isn't it? There's a law called the McCarran-Ferguson Act passed many decades ago, which exempts the insurance industry from antitrust. And a corollary to that has been what's called McCarran-Ferguson reverse preemption, meaning that if a case is brought under state law, the insurance industry says, well, wait a second, this impacts if the case, is brought under federal law, such as RICO, the insurance industry can try to get that case dismissed, or the defendant can try and get the case dismissed on the ground that is reverse preempted by the McCarran-Ferguson Act, which gives to the states sole jurisdiction over regulation of insurance.
And so that was one of the hurdles to overcome, whether, in fact, your RICO claim was preempted under this federal act. And the Court of Appeals said it wasn't.
Correct.
Essentially.
Correct.
This case, Brown versus Cassens, the one that was published at the end of October, it had been dismissed in the district court, and after that, it was the Court of Appeals affirmed that dismissal. Am I correct?
Correct. 2-1.
And then you appealed to the United States Supreme Court, and then what happened after that?
Well, my appeal from the district court to the Court of Appeals, I asked the Court of Appeals to overturn this 1984 precedent in which the Court of Appeals had ruled that a civil RICO claim requires a plaintiff to allege a misrepresentation made to him upon which he relied. For example, let's say I offer to sell you the Brooklyn Bridge, and you say, "Sure, here's $10,000." Then I skip town. You've relied upon my misrepresentation that I own the Brooklyn Bridge. The old precedent from the Court of Appeals said that there had to be misrepresentation to the plaintiff upon which he relied. My appeal to the U.S. Supreme Court and to the Court of Appeals was that, no, this is not what the RICO law says. So when the first appeal to the U.S. Court of Appeals was heard, I think in 2006, 2005, the Court of Appeals 2-1 affirmed their old precedent. I then applied for rehearing en banc, which means asking all of the judges of the Sixth Circuit to hear it. They refused. I filed a petition for certiorari, that's the name for an appeal, to the U.S. Supreme Court. And another person somewhere, another case in the United States was also appealed a few weeks before me. And about, I think it was in June of this year, the U.S. Supreme Court heard this other case, vacated that old precedent of the Sixth Circuit and ruled that a plaintiff does not have to allege a misrepresentation made to him upon which he relied. The plaintiff only has to allege fraudulent scheme in which the mails or the wires were used in furtherance of that scheme. So the case then went back down to the United States Court of Appeals, Sixth Circuit, for decision on the remaining issue. And the main remaining issue was whether or not the McCarran-Ferguson Act reverse preempted my claim against Cassins and Crawford and Company. And the Sixth Circuit said it did not, that the Workers' Comp Act was not an act of insurance, and et cetera, and that decision on October 23rd last month clears the way for me to proceed full force unless, and here's the fly in the ointment, the defendant on Friday, I just received yesterday, in fact, a motion for hearing on bank by the defendants trying to get the entire Sixth Circuit to reverse the decision of October 23rd. I don't believe it will be reversed. If it does, then I got real problems. If it doesn't, then we go back down for full blast discovery against the defendants in this case, and then I'm frankly going to file other cases because this is a big problem and I want to attack it wherever it has occurred.
And I definitely want to talk about that. So as it stands right now, with the most recent decision from the Court of Appeals, you've gotten over the first hurdle. Essentially, the door is open for your lawsuit to proceed into the discovery stage. Is that a fair statement?
Barring a motion for reconsideration on bank and reversal of the opinion of October 23rd, that is correct.
Now let's talk about what the discovery involves. You know, the discovery stage is all the fact gathering that goes on in the case. And under RICO, I understand there's special discovery rules that give a plaintiff a little more power, or a little more fact-gathering power than in a normal civil suit. Could you explain on that a little bit?
Yes, there are several elements where RICO is a very powerful tool. One is that I'll be able to investigate all workers' compensation claims handled by the defendants in the relevant period, not just the 6 that I've pled. Because I can look for what are called predicate acts or acts of racketeering by the defendants that involve other workers. And they're not going to like that, but that's really going to be powerful because I may be able to uncover other claims. These people may become plaintiffs, and even if they don't become plaintiffs, well, that's proof that, in fact, there is a pattern of racketeering. Secondly, I'll be able to get, of course, all correspondence and emails among the defendants. And third, I will request the discovery of all correspondence and emails between the defendants and their attorneys, their workers' comp attorneys, and ask the court to examine what they call an in-camera inspection of those emails correspondence to see if any of them were in furtherance of the fraud. That's a huge
and that's one thing I want to talk about. Communications between attorneys and their clients are in almost the entire legal world are privileged, and the other side in a lawsuit is not able to discover what those communications are and the contents of the communications between the other side's attorney and their client. And under RICO, as you explain it and as I understand it, you are allowed to look at communications between the insurance company's attorneys and the doctors, the medical examiners. Is that right?
Well, not quite like that. The law is not crystal clear, but there is law saying that I can request an in-camera inspection by the court, not by me, of that email and that correspondence to see if any of that was in furtherance of the fraud. For example, if the workers' comp attorneys were directing the use of Dr. A or Dr. B, or explaining to the claim adjuster what to put in the false notice of dispute, that would certainly be discoverable by the court, and then it would be turned over to me.
I want to sort of switch gears and talk about, sort of tell the viewers, injured workers or whoever they may be watching the show, what would you tell them, a working individual or someone who's injured on the job, how would you explain to them the significance of this lawsuit and what it really means to injured workers around the country, not just in Michigan?
Well, I'm not sure what it means in other states because I'm not sure what the laws are in other states. For example, I don't know if the laws of other states, provide some remedy for fraudulent use of IME doctors or fraud by the IME doctors or for fraudulent denial of workers' comp by a claim adjuster. If the state law provides no remedy, then it's certainly feasible to consider that RICO would provide a remedy. And I think that this is a template which could be used nationwide if the evidence is there.
But of
course, what is the proof of fraud? And that raises a very interesting question. How do I prove that a doctor who does 1,200 IMEs a year, all for the insurance company, is committing fraud in 100, 200, or 500 of them? That's a very interesting question which is yet to be resolved.
Could you explain, give a few examples in practice of what your experience is with these defense medical examining doctors and what you've heard them say in deposition as far as what they do for the defense and how they're retained and how much money they earn and how biased they are in your experience?
You've asked a whole bunch of things there. Let me talk about money. One doctor in particular that is overused here in southeast Michigan is an orthopedic doctor whose records indicate that he makes about $600,000 a year doing these IMEs and related depositions. Roughly 1,100 exams a year just for this one entity that hires them. We have entities that have a stable of these doctors. This doctor does 1,100 exams a year for this one entity. Presumably no other entities, but I have to find out. So I know this guy makes at least $600,000 a year.
Solely from performing these medical exams on behalf of the insurance company?
Right, and related depositions.
And depositions.
Related depositions. Now, what has he said in his... Well, in my experience, this doctor has never found a person to have a work-related disability. Or with extraordinary rarity. He'll also testify that a job involving repeated lifting, bending, twisting, kneeling, squatting, climbing, heavy lifting, does not aggravate the pathology of arthritis of the knee, which I believe is so far from medical truth that no doctor can reasonably hold that opinion. In other words, it's a fraudulent opinion, in my belief, because the evidence of orthopedic medicine is so clear that repetitive heavy lifting, bending, squatting, kneeling, climbing will contribute to the advanced progression of pathology of osteoarthritis of the knee, for example. The doctor also, or some doctors, I'm not going to say who, because I'm not going to let the cat out of the bag yet, I believe simply lie in their reports and say, I palpated the patient or I put him through a full range of motion. And I've had several patients tell me, no, he didn't do that. He didn't touch me at all. He didn't touch my arms. And, one or two people may say that, be very skeptical. But, for example, earlier today, this is really quite interesting. Just about 5 or 6 hours ago, I talked to a person who was examined by this particular doctor, and that person brought her chiropractor into the room with her. Dr. X, who did the exam, didn't know the man was a chiropractor. Apparently assumed it was her husband. And when Dr. X's report came out, it said that he examined this person's spine. The chiropractor wrote a report saying, no, he didn't. I was there. I saw it. He didn't examine the spine. Now that, to me, is just out-and-out basic fundamental lying. And that is going to be, I think, help make a prima facie case. That's one of the. So in other words, you have false statements in the reports. Simple things like that. Doctor says I examined this when he didn't. I touched this when he didn't. Patient gave me this history, and the patient said I never gave that history. Or the doctor may say the patient never disclosed a prior injury. The patient says, baloney, I told him about my prior knee injury. Those are questions of fact for a jury. And I'd be happy to put my clients in front of a jury and line up 20 or 30 or 40 of them, all saying, Dr. X said this lie, Dr. X said that lie, and here's Dr. X having to rebut each lie. That's going to make a great trial.
Now, one of the questions is, you have several clients who you're representing in these lawsuits. Do you think this problem is more widespread throughout Michigan or throughout the entire country?
I can't speak the entire country, but I sure as heck know it's widespread through Michigan, from my experience. I mean, for example, here's another example. On Tuesday this past week, I was at the deposition by telephone of a Dr. James Wessinger of Lansing or Okemos, Michigan. As is the case with too many of these doctors, he had retired from the practice of medicine 11 years ago. He hasn't done surgery in 11 years. And he admitted that he earns between roughly $650,000 and $900,000 a year doing these IMEs for the last 11 years, all for the insurance companies. To me, that's an absolute outrage that a man should be able to make this kind of money, not practicing medicine, just doing IMEs from insurance companies. He can't be sued, can't be touched under state law, no matter what he says. It is widespread. There are lots and lots of retired doctors who are making $200, $300, $400 a year in Michigan just doing these IMEs for insurance companies.
And I have to imagine that problem is it's not solely contained in Michigan. I'd have to imagine that the same thing goes on in California, the same thing goes on in Nevada, the same thing goes on in every state in this country that has a workers' compensation system.
That's probably a reasonable surmise.
One of the arguments I anticipate from the defense side is how can you prove that these doctors are really acting fraudulently? How can you prove it's not just a reasonable difference of differing medical opinion from your doctors from their doctors? Excellent
question, and it's something I've given a lot of pondering to. One method is, and I think it's going to be very, very powerful, is when you have a client who says, look, Dr. X wrote in his report that I palpated the back. And a client says, no, he didn't. He didn't touch my back. He lifted up my shirt and looked at it. He didn't touch my back. And another client says, he denies that I told him about my earlier knee injury. And that's baloney. I told him about my earlier knee injury. Those right there are questions of fact. And if you can line up 20 or 30 of clients who truthfully and persuasively will tell a jury that Dr. X lied, that is going to call into question every single IME report he wrote. Now, the question is, of course, can they all be overturned? I don't know. I mean, I've really got to think this through as to exactly what proof is required. So one type of evidence, which I think is very powerful, is the client who can truthfully, persuasively tell a jury that Dr. X's report contains lie, this lie, that lie, etc. Another way is when he gives is to have let's say an orthopedic doctor look at Dr. X's report and then look at all the medical records. And if Dr. X says the person can return to work without restriction, when you have a neutral orthopedic surgeon looking at all the records and say that's unconscionable. I mean, no, this is not a matter of a reasonable difference of opinion. This is fraud. This person who was just 8 weeks post arthrodesis of his ankle cannot possibly return to unrestricted manual labor. I mean, it's not within a reasonable difference of opinion. That would be another grounds for saying a particular medical report is fraudulent. A third ground would be to take a position, as I described earlier, which is contrary to medical knowledge, such as the position that some doctors have taken that repetitive heavy lifting, climbing, twisting, and bending and squatting will not cause progression of osteoarthritis when, in fact, it is known that it will, certainly for the knee and other joints also. So those are just three of the... Oh, then the fourth is a statistical approach, and that'll be fun. One particular, you take these doctors. The doctors are making $600,000, $700,000, $800,000 a year, and you will line up all of their reports, examine, let's say, 200 in a row. And if you find that 97% of them find no work-related disability, and on the other side you have, let's say, of those 200 consecutive reports, you might have 50 or 60 or 80 or 90 different orthopedic physicians on the other side, and they all say there's a work-related disability, that is some further evidence that Dr. X is committing fraud. It's not merely difference of opinion. It's such a oceanic difference of opinion that it is fraud. Maybe a statistician would come into play there. I may be hiring a statistician. I'm not sure. So those are 4 points there that I'm considering.
And when it comes to proving your case and accumulating all this evidence, whether it be statistics or having independent neutral doctors review these files to make a determination on an individual case, you yourself have to go out and find someone willing to help you, and some doctor who's willing to work on your behalf and help you uncover this fraud. Now, is that a problem, or is that not?
Darn right, it's a problem, because the medical profession, there aren't many brave people in the medical profession, I have found, and they don't want to stick their nose out. I am looking for orthopods who will be willing to go against Dr. X or Dr. Y or Dr. Z, or at least take a look at his reports, compare them to the medical records, or the treater's medical records, and give me an opinion as to whether Dr. X's, Y's, or Z's opinions are fraudulent, or in other words, so far from any reasonable medical opinion that they are false. I was heartened when on Thursday afternoon, 2 days ago, I did take the deposition of an orthopedic surgeon. In my case, I was the person who took the deposition. And this doctor, who gets 0% of his income doing IMEs, is so upset at what he sees being done by these IME doctors that he said he would help me in some of my cases. Now, that's great, because this doctor, great for my clients whose problems involve the spine, because he's a spine specialist. Now I need an orthopedic doctor who's going to do knees and ankles. And
are you contacting doctors only in Michigan? Are you looking around the country, or where do you think you'd be able to find people to help you out?
I'm looking anywhere, and I'm even looking for a doctor who is a PM&R doctor. We call physical medicine rehabilitation here, also known as physiatrist, because I believe they're also quite capable of testifying regarding knees. Not as well, I'm not. Yeah, knees. I would say so. So I'm looking at those 2 specialties, anywhere I can find them.
What response have you gotten from clients, or I know you work a lot with union members, with Teamsters, with locals. What sort of feedback have you gotten on this case?
These people are thrilled. People are absolutely thrilled. They're proud of me. They know that a lot of people are hurt, badly hurt by these claim adjusters and their IME doctors. I've got a lot of attaboys.
Now, what would you tell? And I know you go and speak with various unions. And what do you tell them? What would you tell someone who believes they're fraudulently cut off benefits and doesn't really know what to do? They don't know if they should hire an attorney, and there's no formal appeals process through the workers' comp system for that. And what are these people supposed to do?
Well, they'll have an attorney for the workers' comp case once they've been cut off due to, let's say, notice of dispute or pursuant to an IME. They'll pursue that. But they can contact me to see if there's a possibility of a RICO case. And I'm certainly looking into a number of cases against a number of corporations and a number of doctors.
What do you think, talking about the future here and the impact this case could potentially have on the insurance system, or more of these suits in the future? Do you have any idea where it's going, or are you just taking it development by development?
Well, I mean, defendants are going to have to pay a lot of money before they get scared enough to change their practices. So hopefully there's going to be a lot of money changing hands, and then they will see that they're going to have to stop using IME doctors who are making $300,000, $400,000, $500,000, $600,000 a year. Maybe special legislation has to be passed, to have a number of doctors who do not have financial ties to either side, who will do IMEs. You got to get rid of the system where a man can make $300,000, $400,000, $500,000, $600,000 a year doing IMEs for insurance companies, or for the plaintiff for that matter, because of the fantastic bias it involves and the fraud that it encourages. I hope that's what the result is.
Do you get the sense that workers' comp, judges or magistrates in Michigan and maybe the courts at the state level also are sort of apathetic to the situation?
Very good question. I've been really bitterly disappointed by the lack of interest the workers' compensation magistrates have shown in my getting and trying to put in evidence financial records of these IME doctors. It's like they don't care about it. They don't think it has any impact, which blows my mind. I mean, if a doctor is retired and he's making $300,000 or $500,000 a year, or in the case of this Dr. Wessinger, $800,000 a year doing IMEs just for the insurance companies, to me, it completely destroys the credibility of his testimony. And yet, I believe that most of the magistrates here, they won't even let me discover, or my colleagues, they won't even let us discover that information. And if we discover it, they don't seem to. I've never ever seen an opinion by a magistrate or the appellate people here in Michigan, called the Workers' Comp Appellate Commission. Never seen an opinion saying this doctor lacks credibility because of the enormous amount of money he's making doing this. And that just defies common sense, and it's really disappointing.
Is it? Do you get the sense that it's that they turn a blind eye to it, or they don't care,
That's what I'm
saying. they turn a blind eye to it?
Yeah, they don't care. They don't care.
And the only way to bring this system to light, the broken system to light, you felt was pursue a RICO claim in federal court.
That's the only thing I found that seems to have a hope of working, fixing the system.
Do you feel that the insurance companies, well, obviously, you feel that the law is on their side in Michigan, and they control the courts in the sense of the laws being in their favor when it comes to denying benefits?
I wouldn't put it that strongly. I would say that I don't say they control the courts. I don't say that by any means, but I do say that there is a serious flaw in the Michigan scheme, and that there is no punishment for fraud, nor any, no punishment or deterrent for fraud, and it allows the insurance companies or any side to use doctors who are making $300,000, $400,000, $500,000 a year doing IMEs for one side.
Do you? Let me see here. Do you know what the other circuits around this country have held as far as any of these claims? Have there been similar decisions in other circuits?
Not to my knowledge.
Not to your knowledge? Have any other attorneys approached you about this, and from other states or organizations from other states saying?
Well, the first organization was the National Organization of Injured Workers. I have also heard from a couple of other attorneys out of state
and
in state.
As far as you know, has anyone told you, I've been working on, I've been thinking about bringing a suit like this in the past and never knew how to go about it? They're asking you for insight as to how to pursue it in another district, in another state, in another circuit?
Have not been asked yet.
and the Supreme Court has never decided an issue like this, as far as you know.
Well,
The United States Supreme Court has never really addressed workers' compensation denial of benefits.
Not on the no, it has not.
In a RICO context. Yeah. And you've been doing this, obviously for a long time, and why did you wait, or why do you felt that right now is the time to do this as opposed to decades ago?
Well, I wasn't even just frankly, it never occurred to me until about 5 years ago that there was this possibility. And also, I must say, it was really only about 5 or 6 years ago that I really became outraged at this persistent, what I see as persistent fraud, and so much of it.
Do your clients often tell you of other cases in which they know of that?
Oh yeah. I'm collecting data every day now. I'm trying to find as many names, talk to as many people. I want to build as big a arsenal of what I believe are false IMEs and fraudulent notices of dispute, because the more you can show, the easier it will be to prove the case.
And do you think this is a type of case that will ultimately end up in front of a jury, or have you had negotiations with the defense side in this to resolve it?
I just received yesterday from the counsel for Cassens and Crawford and Company the motion for a hearing on bank. If they lose that, they would be, I think, idiots to fail to seriously negotiate settlement, because the clock is ticking on the attorney fees. The clock, they're going to have to pay not only their attorneys whatever the $300 or $400 an hour they're paying, they're going to have to pay me the same amount, because my time is certainly worth at least that much, if not more, because I've won. Mm-hmm. And it's going to cost them a lot of money. Plus, there's the risk, and this is what the defendants all around the country should be concerned about. When discovery may disclose fraud, which may result in indictments. Because if I find fraud that is, I believe, crystal clear, I'm going to hustle it over to the Justice Department. And perhaps under President Obama, and in this economic climate, corporate fraud and fraud by the doctors may indeed pique the interest of the Justice Department. So the defendants in this case and other cases are going to have to decide, do we really want to have this attorney and maybe the judge with in-camera inspections rummaging around in all of our claims and correspondence and phone calls and emails?
On that note, I want to wrap it up, and I want to thank you very much for joining us by phone today all the way from Michigan, and congratulate you on your legal victory or victories up until now, and the fight that you're doing on behalf of injured workers in Michigan, and hopefully this will have a nationwide effect. And it's really good work, and I'm sure your clients very much appreciate it, and I want to commend you for that. So thank you very much for joining us, and we'll hope to talk to you soon.
Okay, and I just want to say thank you for your thoughtful questions. You asked a lot of good questions.
Thank you for your thoughtful answers.
Okay, bye.
Take care.